Hello everyone, welcome to the NPTEL online certification course titled Medical Law. Myself Dr. Chaitanya Mittal, medical professional as well as the faculty at IIT Kharagpur. Today we are taking week 2 lecture 6 consent in law. So here we will covering these new concepts, what is mean by the consent, theories of consent, laws relating to consent in India, judicial view on consent. The keywords being used in this lecture, the consent, free consent, which is documented in the section 14 of Indian Contract Act, autonomy, autonomy of patient, medical care. Coming to the introduction about the consent in law. So what do you mean by the consent? Consent means voluntary agreement, compliance or permission given to another person for specific performance. It is an understanding in between two parties or two individuals what thing has to do. To be legally valid consent, it must be given after understanding what is given for and what risk is involved in the act. Consent is a legal requirement of medical practice and not a procedural formality. Theories of consent. Consent is understood and discussed in contradictory way when people rely on different theoretical models. Positivism assumes that there is real consent in factual exchange of medico legal information. Social construction theory talks about how consent can be a complex, ambiguous process, not a simple event. So these are the theory positivism and social construction theory. Functionalists see consent as a formality, a token of respect that is hardly necessary because benign expert doctors contribute to the smooth functioning of the society. Refusal and non-compliance are irrational. English courts usually support the doctors in dispute about consent. Famous example, Bolam versus Fran Hospital Management Committee 1957 1 WLR 582, which has given the Bolam test, which is being used till today in a case of any medical negligence cases. Critical theories shares the opposite view, see consent as a necessary protection for patients against useless, harmful and unwanted interventions, an occasion when doctors are accountable. In critical theory, consent is not regarded as simple or one way of medical information giving, but as an exchange of knowledge between doctor and patient, SOP that together they can make more informed decision. So the consent is being divided into two types mainly. One is the implied consent, another is informed or expressed consent. Again, the informed and expressed consent are divided into two parts. The verbal consent, while speaking, whatever being told verbally to understand, and second, the written, which is the most legally valid document, the written informed consent with the proper signature of the patient as well as the doctor and if possible any relative or the witnesses. And the implied consent through actions or the general practice, like the patient coming to the OPD, okay, please examine. So these all are okay, raise your hand for an vaccination or an injection. So these are the implied consent. The patient raises the hand on asking, okay, let's give an injection. So these all are the types of consent. We will go through it. So express consent. Express consent is also known as informed consent. It refers to a clear and direct statement of agreement. It is given by signing an authorization or even verbally also. So, written or can be verbal. Implied consent refers to an agreement given by a person's action or inactions or surrounding circumstances. It does not require any exchange of words either orally or in writing. For example, if a person walks into an emergency room of a hospital before passing out, he is giving implied consent to be treated until he wakes up. So, till he become conscious or comes in sound of mind, the patient coming to an emergency, it is an implied consent. And secondly, even in emergency, consent is not required, the treatment is to be given immediately by the treating doctor. Consent under torts. Voluntary non-fit injurer implies no harm comes to a willing person. The Latin maxim refers that even if an injury is caused by the other person, so in that case he cannot claim any damages from that person because he himself gave the voluntary consent. For example, a player in boxing match cannot complain of injury if the match is lawfully played. The elements of voluntary non-fit injurer are: A. The plaintiff has the knowledge of the risk, and the plaintiff with the knowledge of risk has voluntarily agreed to suffer the harm. So, these are the two main elements of the plaintiff or the patient who has been told complete knowledge about the risk of giving the consent and the treatment. So, for example, in Hall versus Brooklands Auto Racing Club 1932 1 KB 205, plaintiff went to see car race in which two cars collided. The plaintiff, who was sitting in audience, got injured, but since he was consented to take the risk, as he has himself has went to see the car race, so he has given a consent. In another case, in Ravindra Padmanabhan versus Lakshmi Rajan and another 2007 CPJ 17 NC, plaintiff had a tumor in her breast and therefore went to hospital to have it to be removed, but the doctors without obtaining consent removed her uterus. Court held the doctor responsible and defense of voluntary non-fit injurer was rejected. So, the plaintiff or the patient has went for another organ and the doctor without consent they have removed another organ. So, that is completely a medical negligence case. So, the doctor was held responsible. So, coming to the consent, the word consent is applicable in various Indian laws. So, the various Indian laws are there in which the term consent is very important and how it is applicable. So, first and foremost, the Indian Contract Act, in which the consent is being defined to do the one thing in between the agreement in between the two parties or two individuals to do the one thing. So, that is the main meaning of the consent, which is defined under section 13 of Indian Contract Act 1872 and the section 14, which also has a term, various terms involved with the consent like free consent. Another section in Indian Penal Code 1860, where the consent is very important. The sections are section 87, 89, 90, 92 and 300 IPC. Another Indian law, that is the Criminal Procedure Act 1973, where the section 54 and the section 164A CRPC, where the term consent is very important. Another, the Medical Council of Indian Regulation 2002, where the consent is also has an important value. Another, the MTP Act 1971, that is a Medical Termination of Pregnancy Act, which is now being as an amendment act in 2021. Another, the Telemedicine Practice Guidelines 2020. Another Indian law, that is a PCPNDT Act 1994, preconception and prenatal diagnostic techniques, Prohibition of Sex Selection Act 1994, and the last New Drugs and the Clinical Trial Rules 2019. So, in these various Indian laws where the term consent is being used and has its own importance in among these various laws. So, the Consent under Contract Act, section 13, the section defines the consent as when two or more person or two or more party agree upon the same thing in the same sense. So, the same scenario and with the same understanding. So, that is the main meaning of the consent, which is defined under section 13. For an example, A agrees to sell his car to B for a certain price and B is willing the price. This implies that both A and B agree on the same thing in the same sense, that there is a consent. Or if a patient coming to a doctor for a treatment, okay. So, coming to an OPD to show himself or herself is an implied consent. Then for doing any procedure, the doctor is again asking for a written consent and explaining the risk involved and get a written consent by the patient. So, that is also an agreeing for the same thing in the same sense of that particular procedure to be done in that patient. So, section 14 states what constitutes the free consent. The free consent is constituted when it is not constituted by the few terms which are very important, which defines as a voluntary consent or the free or voluntary consent. The term coercion, undue influence, misrepresentation, mistake. So, when it is not constituted, so these should be not there in the consent. The consent should be free and voluntary without these things, that is a coercion, undue influence, misrepresentation, mistake by any force. Okay. So, these things should not be there in a consent, it should be completely free and voluntary. So, coming to the scenarios, in Chikam Amiraju versus Chikam Sheshma 1917, 5 LW 735 FB, court held that to commit suicide amounted to coercion and the consent obtained not constituted as free consent. Similarly, in another scenario where the Rangana Kama versus Alvar Sethi ILR 1889 13 MAD 214, coercion was employed by relatives on the widow to adopt a child, and thus the consent provided therein was not a free or voluntary consent. Coming to the various sections of the IPC in which the consent has its own importance and value. So, first the section 87 of IPC, which says that the consent given by a person above 18 years devoid of intention or knowledge of death or grievous hurt. Second, section 88 IPC, consent given by any person for an act done in good faith for his benefit, but such act must not be done with intention of causing death through such knowledge may be present. For an example, medical treatment involving surgical procedures. Next, section 89 of IPC, any act done for the benefit of a child under the age of 12 years of age or unsound of mind with the consent of guardian or any person having lawful charge of such person comes under section 89 of IPC. It is for a child which is below 12 years, or second for mentally incapable or unsound of mind. Next, section 90 of IPC, a consent is not a consent if the consent is given by a person due to injury, due to mistake of fact, who is insane person, who is intoxicated, or whose age is less than 12 years of old age. Next section of IPC 92, an act done in good faith for the benefit of person without consent is not an offence under 4 limitation intended to death, hurt, grievous hurt or abandonment. Next, section 300 of IPC, culpable homicide is not murder when person whose death is caused being above the age 18 years suffers death or takes the risk of death with his own consent. So, coming to the scenarios, various case scenarios in which have gone through these sections and the consent. So, first in the case of Rao Harnaran Singh Shioji Singh versus the state, AIR 1958 PH 123, the court said that all consent involves submission, but not all submission is consent. Similarly, in another scenario, in Sukaru Kaviraj versus the Empress 1887 ILR 14 CAL 566, doctor had acted negligently and not in good faith, thus could not exercise the defense under section 88 of the Indian Penal Code 1860. So, coming to the next case, in Rekha versus State 2023, the current one, AIR Bombay R 685, Bombay High Court observed that when a student is sent by his parent to a school, the parent or guardian must be said to have given implied consent to his being under the discipline and the control of the school authorities and to the infliction of reasonable punishment for correcting him. So, coming to the next, for the Criminal Procedure Code 1973, where the consent has its own importance. So, section 54 of CRPC, the magistrate may direct the medical examination of the person if requested by him. Another section, section 164A CRPC, medical examination of a victim of rape or sexual assault after receiving the consent of the victim through a registered medical practitioner. The medical examination of the victim can be done under section 164A CRPC. So, another act or the another Indian law, that is the MTP Act 1971, which is now the MTP Amendment Act 2021, section 3(4)(b) of the Act mandates the presence of valid legal consent for the termination of pregnancy. So, the termination of pregnancy in minors or lunatics or the mentally unsound person only with the consent in writing of guardian be allowed. Second, termination of pregnancy in adult women permissible with their valid consent only. In 2017, Supreme Court, while upholding the decision of Punjab and Haryana High Court in the case of Anil Kumar Malhotra versus Ajay Pasrisha review petition number 2939 of 2017 year, states that the woman has the right to decide about the abortion and that consent of the husband is not required. So, in this judgment, it has been clear that for the case of abortion, the valid consent of the mother is fine, is sufficient. The husband consent is not mandatory, but it is always good to inform to the husband and take the consent, but mandatory word has been removed with this judgment. So, only the woman or the mother has the right to either undergoes the abortion or not. Next section, section 5 of the PCPNDT Act, that is a preconception and prenatal diagnostic techniques prohibition of sex selection Act 1994, mandates to obtain written informed consent of the woman undergoing prenatal procedures. So, that it has been clear that in that consent that the mother is not going for a sex determination of the fetus. It is being only done to check for any fetal anomaly or any prenatal procedure. So, it is mandatory to have a written consent by the mother to be done under section 5 of the PCPNDT Act 1994. The procedure shall explain to her in her own language which is she understand, and copy of the written consent shall be provided to the mother or the woman. Another, the Medical Ethics Regulation 2022 Code talks about the consent of the patient. According to the regulation 7.16, before performing the operation, the physician should obtain the consent in the written form, should have obtained valid informed written consent from the husband or a wife or parent or a guardian or patient himself, within having a witnesses as well as signature of the doctor. In the operation which may result in sterility, the consent of both the husband and the wife is mandatory. It is not only the husband or only the wife, both their consent should be mandatory in case of the operation undergoing for an sterile procedure, sterility. Also under regulation 7.17 warrants medical practitioner to not to publish any photograph of their patient without the consent of the patient if by any manner their identity could be made out. So, it is necessary to no need to reveal the identity of the patient in anyhow, either publishing their photographs or publishing their case without their consent. So, the medical professional should take a valid consent if they want to publish any case, even any photograph related to the patient or patient procedure, so that identity should not revealed out. Consent of the female patient, her spouse as well as the donor is mandatory while performing the act of in vitro fertilization under regulation 7.21. So, in case of undergoing this procedure for an in vitro fertilization, the consent of the donor who is being given, either the donor of the sperm or the donor of ova, and the spouse of that particular woman or the female patient, their valid written consent is mandatory under regulation 7.21. Another regulation 7.22 says that it also deals with the consent involved during research or trial of drug or therapy on a person. Paragraph 3.4 of the Telemedicine Practice Guidelines 2020, which is also part of ethics regulation, lays down that the patient consent is necessary for any telemedicine consultation. Such consent may be expressed or implied. So, in the case of telemedicine, when the patient is not able to come physically, the doctor has to take few further or new precautions, that the consent or a videograph or a video of the consultation is mandatory. So, that the person or the medical professional will not be held responsible in case of any mishap. So, that was being explained in the paragraph 3.4 of the Telemedicine Practice Guidelines 2020. Next, in a case of New Drugs and Clinical Trial Rule 2019, the third schedule of it deals with the free, informed and written consent required from each subject in undergoing any clinical trials. So, now coming to the important judgments of informed consent, or the properly the consent being has been taken or not, or what is the being the role or the important aspect of the consent being explained in these judgments. So, first, in Common Cause versus Union of India 2018 5 SCC 1, Supreme Court held that withdrawing life support in permanent vegetative state or in a terminal stage of illness is not prohibited by law within the willing of section 43 and 92 of the Indian Penal Code 1860. Honorable Justice D.Y. Chandrachud, as he was then, elaborated the consent of free will as consent postulates that the individual is in a mental condition which enables him or her to choose and to decide on a course of action and convey this decision. Its voluntary in nature is premised on its consensual character. In another case or another judgment in K.S. Puthuswamy versus Union of India 2017 10 SCC 1, Supreme Court conceives of the right to privacy as involving the right to choose and specify. The right to choose necessarily involves the choice about whether to disclose information, whereas the right to specify encapsulates the right to decide who gets to the access of information. In another judgment, in Samira Kohli versus Prabha Manchanda 2008 to SCC 1, the Supreme Court provided useful guidelines for showcasing the importance of the consent of the patient. It held that where a patient consent is taken for a diagnostic procedure or surgery, such consent cannot be categorized as consent to perform therapeutic surgery, whether conservative or radical, except in life threatening situations. Second, being told in this judgment, where a patient consent is taken for a particular procedure, that consent cannot be used for an additional procedure. A medical practitioner would only be permitted to withhold information in two situations: a genuine emergency where the patient is temporarily incompetent or unconscious; second, where the information would be harmful to the patient. So, coming to the conclusion of our lecture, the consent in law. Consent finds important role in law. Consent can be written or oral or even ascertained through the surrounding situations. To constitute a legal consent, it must be free, voluntarily, uninformed and without any coercion or force or mistake or mishap. In India, consent plays vital role in numerous situations and regulated by various legislation. So, the consent is very important, and secondly importance is to be taken properly written valid consent by any professionals, any medical professional for any type of procedure. So, these are the references, the students can go through these references. The first, Nandimath Ovi, the book Consent and Medical Treatment. Second, the theories of consent from the BMJ. The third, informed consent to clinical research in India. So, these are the references. You can further go through it and learn about the importance of consent in law. Thank you.